to come after us, which could end up in theatrical ignominy. All this while, scant attention has been paid to what I consider a majestic directive principle in our Constitution, a tool of analysis that, faced with such questions as the ones I have posed, a court of law must deploy. And I make reference to Article 259 of the Constitution, the marginal note of which reads, construing the Constitution, or construing this Constitution. And instructively, this provision is preceded by another, which I consider as a defensive armor gifted to our vigilantes of democracy and the rule of law. And this is Article 258(1). And so I go on and on, that by the end of the day, in answer to the issue as so formulated, I arrive at a conclusion to the effect that the so-called basic structure doctrine is not applicable in Kenya. I go on to consider the extent if it is so applicable, but having arrived at that conclusion, I then limit myself to some of the statements and pronouncements that were made by the two superior courts, that is to say, the High Court and Court of Appeal. In this process, I arrived at a conclusion that, contrary to what was decided in error, if you ask me, there is no provision in our Constitution that is unamendable. The question for us to ask is whether the Constitution of 2010 has within it comprehensive provisions, directive principles, and normative prescriptions